The case management system alert hit my phone at 2:17 a.m., flagging unauthorized access to the Meridian Industries file. I stared at the notification from my home office, coffee growing cold beside 3 banker's boxes of discovery documents. Sebastian Blackstone, 42, technology transactions partner at one of Austin's most prestigious law firms. 20 years of practice had taught me that middle-of-the-night system alerts usually meant one thing. Someone was where they shouldn't be. The Meridian deal was our biggest transaction this quarter, a $340 million acquisition requiring absolute confidentiality. Only 4 attorneys had access to those files. I pulled up the access logs on my laptop, scrolling through timestamps and user credentials. There it was. Logan Dunmore, our chief financial officer, had accessed the file at 2:03 a.m. Not unusual for Logan to work late, but CFOs don't typically review privileged attorney-client communications, especially not transaction documents sealed under 3 separate non-disclosure agreements. I clicked deeper into the logs. Logan had downloaded 17 files. Email chains between our client and their board of directors. Internal memos discussing deal structure and potential regulatory hurdles. Documents that could tank the entire acquisition if they reached the wrong hands. My phone buzzed again. Another alert. This time from our billing system. Someone had generated a detailed report of all Meridian-related time entries and expenses. The timestamp showed 2:19 a.m. Logan's credentials again. I leaned back in my chair, studying the pattern. In 15 minutes, Logan had systematically accessed and downloaded our most sensitive client files, then pulled comprehensive billing data. The kind of information that would give someone complete insight into our legal strategy, client vulnerabilities, and internal operations. The rational explanation was simple. Logan was preparing financial projections for the partnership meeting next week. CFOs needed broad access to evaluate firm profitability and resource allocation. But something felt wrong about the timing and scope of his digital footprint. I opened my secure email and found 3 new messages from Meridian's general counsel. The subject lines made my stomach drop: confidentiality concerns, urgent, potential information breach, and emergency call required. The first email was timestamped 11:47 p.m. Pacific Time, 4 hours ago. Sebastian, we've received concerning information suggesting our confidential communications may have been compromised. Please call immediately upon receipt. This cannot wait until morning. I grabbed my phone and dialed. The call went straight to voicemail. 20 years of practice, hundreds of deals, thousands of confidential files. I'd never seen anything like this pattern of access and timing. Logan had downloaded sensitive client files just hours before our client reported a potential breach. The case management system chimed again. Another alert. Logan was still online, still accessing files. This time he'd opened the Hartwell merger documents from last month. Then the Blackstone Industries transaction files from 6 weeks ago. My own family name on the screen made me pause. That deal had been particularly sensitive, involving my distant cousin's tech startup. I'd disclosed the relationship and recused myself from key decisions, but Logan would have known about the family connection. I watched the real-time access logs update every few seconds. Logan was methodically working through our highest-value client files, downloading documents and generating reports, the digital equivalent of photocopying our entire practice. My phone rang. Unknown number. Mr. Blackstone? This is Beatrice Dunmore from the State Bar's Ethics Division. I apologize for the late hour, but we've received a complaint regarding potential attorney-client privilege violations at your firm. We need to schedule an immediate interview. The line went dead before I could respond. I stared at my laptop screen, watching Logan's continued file access in real time. The timestamps painted a clear picture of systematic data extraction, but the bigger question remained. What was he planning to do with our client's most sensitive information? The State Bar complaint arrived by certified mail 3 days later. Beatrice Dunmore's signature appeared on official letterhead, requesting my immediate cooperation in an investigation of potential systematic breaches of attorney-client privilege and unauthorized disclosure of confidential information. I'd been expecting this. What I hadn't expected was the scope. The complaint listed 17 separate incidents spanning 8 months. Client names I recognized. Deal structures I'd negotiated. Confidential terms that should have existed only in our secure files. And the minds of the legal teams involved. Logan Hartwell had been my technology transactions partner for 6 years. We'd built our practice together, starting with small software licensing deals and growing into 9-figure mergers. He understood complex data structures better than any attorney I'd worked with. That expertise had made him invaluable. It had also made him dangerous. I pulled the access logs from our case management system, cross-referencing them with the dates in the state bar complaint. The pattern was unmistakable. Logan had accessed confidential files within hours of each alleged breach. Sometimes minutes. The Meridian software acquisition in March. Logan downloaded the due diligence reports at 2:17 a.m. Our client reported a competitor's suspicious knowledge of their intellectual property portfolio the next morning. The Dataflow merger in June. Logan accessed the financial projections at 11:43 p.m. on a Sunday. The target company's board received an anonymous tip about undisclosed liabilities 48 hours later, nearly derailing the deal. We co-led a multi-firm merger last September involving 3 Austin tech companies and a California venture capital fund. Logan had access to everything: financial statements, employee agreements, proprietary algorithms, customer lists. The deal collapsed when confidential pricing information appeared in a competitor's bid proposal. I'd attributed the failures to bad luck, market volatility, due diligence gaps. Never suspected internal sabotage. My phone buzzed. Text message from an unknown number. Check your personal email. Important information about your partner. I opened my laptop and logged into my personal Gmail account. One new message from a Proton Mail address. No subject line. Mr. Blackstone. I work in IT security for a major Austin law firm. I cannot identify myself, but I have information about systematic data theft at your firm. Your partner Logan Hartwell has been forwarding privileged client emails to his personal inbox for 8 months. I have proof. Meet me at Mozart's Coffee on Lake Austin tomorrow at 2 p.m. Come alone. Look for someone reading the Austin Business Journal. I deleted the email immediately, then thought better of it and checked my trash folder. Already gone. Whoever sent it had used a self-destructing message service. The next afternoon, I sat at Mozart's overlooking the lake, scanning faces and newspapers. A woman in her 30s approached my table. Austin Business Journal folded under her arm. Mr. Blackstone? I'm Beatrice Caldwell. I sent the email. She sat down without invitation, placing a manila envelope on the table between us. I work for a cybersecurity firm that monitors email traffic for several Austin law firms. We detected unusual patterns in your firm's outbound communications 6 weeks ago. Your IT department never requested our services, but we were hired by one of your clients to investigate potential data leaks. She opened the envelope and slid out a stack of printed emails, all from Logan's firm account to his personal Gmail address, all marked confidential or attorney-client privileged. He's been forwarding selective emails since last October, not everything, just the most sensitive communications. Deal terms, client strategies, financial projections, always to the same personal account. I recognized the email headers. Messages I'd sent to Logan about client negotiations, internal strategy discussions, confidential settlement terms. Why are you showing me this? Because your clients deserve to know. And because Logan approached my firm last month, asking about our services. He wanted to know if we could detect email forwarding patterns. When I ran a preliminary scan, I found his own forwarding history. She pulled out her phone and showed me a screenshot. Logan's Gmail account had received 847 forwarded emails from our firm's system. The oldest dated back 8 months. He's been building a database of your client's confidential information. The question is what he plans to do with it. That evening, I accessed our billing system and ran a detailed report on Logan's client development activities. The numbers told a disturbing story. Logan had brought in $2.3 million in new business over the past 8 months, all from clients whose confidential information had been compromised. Companies that had lost deals to competitors who somehow knew their negotiating positions and financial constraints. The pattern was elegant in its simplicity. Logan would access confidential information about our existing clients' deals and strategies. That information would somehow reach competitors or potential acquirers. When our clients' deals failed or faced unexpected challenges, Logan would approach them with solutions, positioning himself as the attorney who could prevent future problems. He was sabotaging our clients to generate his own business. I printed the billing reports and access logs, then locked them in my office safe. Tomorrow I would need to make some difficult phone calls. To our managing partner. To the state bar. To clients who trusted us with their most sensitive information. But first, I needed to understand the full scope of Logan's operation. How many clients were affected? How much confidential information had been compromised? And most importantly, who was helping him? Because Logan was brilliant with technology, but he wasn't a hacker. Someone had given him access to our email forwarding capabilities. Someone had helped him cover his digital tracks. Someone inside our firm was working with him. I opened our employee directory and started making a list of everyone with administrative access to our email system. The list was shorter than I'd expected, but it included one name that made my stomach drop. Our chief financial officer had been with the firm for 12 years. She handled all our technology contracts, including our email security services. She would have known exactly how to enable Logan's forwarding scheme without triggering automatic security alerts. And she would have known which clients had the most valuable confidential information worth stealing. The confrontation had to be surgical, no room for denial or destruction of. I arrived at the office at 6:30 a.m., 2 hours before Beatrice Dunmore typically started her day. The building felt different in the early morning silence, as if the walls themselves were holding secrets. I'd spent the weekend documenting everything. Logan's email forwarding patterns, the correlation between client information access and his new business development, the administrative logs showing Beatrice's system modifications that enabled the scheme. The correlation was overwhelming, but I needed one final piece: proof of their coordination. I accessed our firm's instant messaging logs through my administrative privileges. Partners rarely used the internal chat system, but support staff relied on it constantly. If Beatrice and Logan had communicated about their scheme, there might be traces. The search took 40 minutes. Most conversations were routine IT support requests and scheduling coordination. But buried in the logs from 3 months ago, I found what I was looking for. Beatrice to Logan. Email routing updated for your client development project. New prospects should receive the information packages automatically now. Logan to Beatrice. Perfect timing. The Meridian deal closes next week. Their competitor will be very interested in our alternative proposal. They weren't even trying to hide it. The arrogance was staggering. I printed the chat logs and added them to my file. Then I called our managing partner, Beatrice Thornfield. Sebastian, it's barely 7 in the morning. This better be important. We need to meet immediately. Bring the executive committee. We have a serious problem. The emergency meeting convened at 8 a.m. in the main conference room. 5 partners sat around the mahogany table, their faces reflecting varying degrees of concern and irritation at the early hour. I laid out the methodically. The email forwarding scheme, the client information theft, the coordinated business development strategy, the chat logs proving conspiracy between our CFO and one of our partners. The room fell silent as I finished my presentation. How long has this been going on? Beatrice Thornfield asked. At least 8 months, possibly longer. I've identified 12 clients whose confidential information was compromised, resulting in failed deals worth approximately $47 million in lost value. Partner Logan Westbrook leaned. Are you certain about these allegations? This could destroy both their careers. The digital is conclusive. Logan forwarded 847 privileged emails to his personal account. Beatrice modified our email security settings to enable the forwarding without triggering alerts. The timing correlation between information access and Logan's new client acquisitions is mathematically impossible to explain as coincidence. Beatrice Thornfield stood up. We need to contact the State Bar immediately. And our malpractice insurance carrier. This is going to be a nightmare. The next 3 hours were a blur of phone calls and emergency protocols. We suspended Logan's access to all firm systems and placed Beatrice Dunmore on administrative leave pending investigation. Security escorted both of them from the building by noon. The State Bar's Ethics Reform Advisory Panel moved quickly. Senior billing fraud reviewer Chloe Simmons arrived that afternoon to begin the formal investigation. I've seen technology-enabled theft before, but this level of sophistication is unusual, she told me during our initial interview. The coordination between your CFO and partner suggests this was a long-term operation, not an opportunistic crime. The investigation expanded rapidly. Chloe's team discovered that Logan and Beatrice had been planning their scheme for over a year. They'd identified high-value clients, mapped their deal timelines, and developed a systematic approach to information theft and business development. The financial damage was worse than I'd initially calculated. 18 clients had been affected, not 12. The total value of compromised deals exceeded $73 million. Client lawsuits began filing within a week. Our malpractice insurance carrier launched their own investigation. The local legal community buzzed with rumors about the scandal at one of Austin's most prestigious firms. But the most difficult part was the personal betrayal. I'd worked alongside Logan for 6 years. We'd collaborated on dozens of deals, shared late-night strategy sessions, and built what I thought was mutual professional respect. The realization that he'd been systematically stealing from our clients while maintaining our friendship felt like a physical wound. The State Bar hearing took place 6 weeks later. Logan and Beatrice both faced multiple charges: breach of fiduciary duty, theft of confidential information, conspiracy to defraud clients, and violations of professional conduct rules. I testified for 3 hours, walking through the digital and explaining how their scheme had operated. Logan sat at the defendant's table, avoiding eye contact. Beatrice stared straight ahead, her expression unreadable. The panel's decision was swift and severe. Logan received a 5-year suspension from practice and was ordered to pay $2.4 million in restitution. Beatrice faced criminal charges for computer fraud and conspiracy. Our firm implemented new security protocols and hired a forensic technology consultant to prevent future breaches. We also established a client compensation fund to address the financial damage from the scheme. The hardest conversations were with the affected clients. Explaining how their trusted advisors had betrayed their confidence and damaged their business interests required a level of professional humility I'd never experienced. Most clients appreciated our transparency and cooperation with the investigation. 3 chose to continue their relationships with our firm under new partner assignments. Others understandably moved their business elsewhere. The scandal cost us approximately $12 million in lost revenue and legal fees, but it also revealed the strength of our firm's ethical foundation. The partners who remained committed themselves to rebuilding trust and implementing stronger oversight procedures. 6 months after the initial discovery, I found myself in an unexpected role. Several junior associates had been unfairly blamed for security lapses that were actually caused by Logan and Beatrice's scheme. They faced potential termination despite having no involvement in the conspiracy. I began representing these associates in their employment disputes, helping them clear their names and secure appropriate compensation for the damage to their careers. The work felt meaningful in a way that technology transactions never had. These young lawyers had been collateral damage in a scheme they couldn't have prevented or detected. They deserved advocates who understood the complexity of what had happened. 12 months later, I stood in my new office overlooking Lady Bird Lake. The nameplate on my door read, Sebastian Blackstone, Employment Defense Attorney. The transition from technology transactions to employment law had been smoother than expected. My practice focused on representing attorneys facing unfair disciplinary actions and junior associates caught in firm politics beyond their control. The work felt purposeful in ways that merger agreements never had. The phone rang at 2:15 p.m. Another associate from a downtown firm, terminated after questioning billing irregularities that turned out to be legitimate concerns. I represent junior associates in unfair termination cases, and business had been steady. The legal community in Austin was smaller than most people realized. Word traveled quickly about attorneys who stood up for their colleagues when firms tried to scapegoat innocent lawyers for management failures. Logan Dunmore had served 8 months of his suspension when he moved to Dallas to work in compliance consulting. Beatrice Dunmore received 18 months in federal prison for computer fraud. She was scheduled for release next spring. Our former firm had recovered most of the stolen funds through insurance claims and asset seizures. The new security protocols had prevented any similar breaches, though trust took longer to rebuild than technology. I kept in touch with several partners who had supported the investigation. They reported that client relationships had stabilized and new business was returning to pre-scandal levels. The compensation fund had resolved most claims without litigation. My current caseload included 12 employment matters, ranging from partnership disputes to associate termination appeals. Each case reminded me why the legal profession needed advocates willing to challenge institutional power when it was misused. The sunset painted the lake orange and gold as I reviewed files for tomorrow's depositions. A young associate from a prestigious firm had been fired for refusing to alter billing records. Her case would go to arbitration next month. These battles were smaller than the multi-million-dollar transactions I used to handle, but they mattered more. Every attorney deserved fair treatment and due process, regardless of their position in the firm hierarchy. The betrayal at my former firm had taught me that loyalty and ethics weren't always aligned with institutional interests. Sometimes protecting the profession meant challenging the institutions that claimed to represent it. My phone buzzed with a text from the associate I was representing. She had received a settlement offer that included full reinstatement and back pay, another small victory in the ongoing effort to hold law firms accountable for their treatment of employees. I closed the file and looked out at the water. The city lights were beginning to reflect on the lake's surface, creating patterns that shifted with each gentle wave. The legal profession would always attract people who prioritized personal gain over professional responsibility, but it also attracted lawyers willing to fight for justice, even when the fight was difficult and the rewards uncertain. My practice was thriving, my conscience was clear, and I slept better than I had in years. The work of rebuilding trust and protecting vulnerable attorneys would continue, one case at a time. It was finally over, and the silence felt earned.